Most people don't get charged because they broke the law. They get charged because they talked. That statement makes people uncomfortable. It feels unfair. It feels like I'm blaming the driver instead of the system. But after reviewing hundreds of body camera videos, reading transcripts line by line, and standing in court during suppression hearings where everything turns on a single sentence uttered on the side of the road, I can tell you something that may sound harsh but is undeniably true. Traffic stops don't escalate because of sirens. They escalate because of words. There is one phrase that could prevent most of that escalation, and it's not aggressive, it's not hostile, and it's not magic. It is calm, steady, and legally grounded. The phrase is simple. I don't consent to any searches, and I would like to remain silent. That is the anchor. Everything in this conversation circles back to that sentence. Let me explain why. I have watched footage where someone is pulled over for a broken taillight. The officer approaches, polite but probing. Where are you coming from? Heading anywhere important tonight? Mind if I take a quick look in the car? The driver smiles. They laugh nervously. They answer every question because that's what we're conditioned to do. We're conditioned to cooperate. We're conditioned to believe that cooperation equals safety. Here's where this gets complicated. The Constitution does not require you to help build a case against yourself. The Fifth Amendment protects your right to remain silent. The Fourth Amendment protects you from unreasonable searches. But those protections are not self-executing. They don't activate automatically. In court, judges ask one question. Did the person clearly assert their rights? If you never clearly say the phrase, those rights shrink. One of the most common mistakes I see is over-explaining. A driver gets stopped for speeding. The officer asks, "Do you know how fast you were going?" The driver says, "I was probably going a little fast, but I'm late for work and my speedometer might be off." That sentence alone can convert a civil infraction into a prosecutable admission. In some jurisdictions, that probably becomes evidence of knowledge. Knowledge becomes intent, and suddenly the ticket becomes reckless driving. This is the trap. People think being conversational will soften the encounter. They don't realize that officers are trained to ask open-ended questions designed to elicit admissions. Not because every officer is malicious, but because that is how investigations work. An officer who smells alcohol will not begin with, "You're under arrest." They will begin with, "Have you had anything to drink tonight?" Most people say, "Just one." In court, just one becomes an admission of consumption. That admission justifies field sobriety tests. Those tests justify arrest. Now this is the part most people misunderstand. Silence feels suspicious. It feels like you're making things worse. And yes, let me be honest with you, asserting your rights can make the stop longer. It can irritate an officer. It can change the tone. That is the hard truth. You may sit there in awkward silence while they run your license. You may feel tension building in your chest. But awkward silence does not create probable cause. Your words might. I defended a case where a simple registration stop turned into a felony possession charge. The driver consented to a search because he believed he had nothing to hide. What he forgot was that a friend had borrowed his car earlier that week. Officers found contraband under the passenger seat. The entire case hinged on consent. The body camera showed the officer asking, "You don't mind if I take a quick look, do you?" The driver shrugged and said, "Go ahead." That shrug was consent. In court, we argued coercion, but the judge replayed the footage. Calm voice, no raised tone, no drawn weapons, consent upheld. Case survived suppression. Had he said the anchor phrase, "I don't consent to any searches, and I would like to remain silent," the legal landscape would have shifted entirely. Without consent, the officer would have needed probable cause or a warrant exception. The search may never have happened. But here's where it turns. Officers understand psychology. They understand that most people fear looking guilty, so they frame requests in a way that makes refusal feel incriminating. If you've got nothing to hide, you won't mind. That sentence is powerful because it appeals to your ego. It suggests that innocence equals openness. Legally, that's false. Innocence equals rights. Another mistake that turns tickets into charges is volunteering information that broadens the scope of the stop. The Supreme Court has said that a traffic stop must be reasonably related in scope and duration to the reason for the stop. That means if you're pulled over for a cracked windshield, the encounter should revolve around the windshield. But if you casually mention that you're coming from a party or that you were in a hurry because you were arguing with someone, you have just expanded the universe of inquiry. This is where ambiguity becomes a tool. Officers are trained observers. Shaking hands, that's nervousness. Avoiding eye contact, suspicious. Too much eye contact, also suspicious. The ambiguity works in one direction, toward investigation. Your job is not to win a personality contest on the roadside. Your job is to minimize exposure. Adrenaline complicates everything. When those lights flash behind you, your heart rate spikes. Cortisol rises. Fine motor skills decline. People talk more when they're anxious. They ramble. They fill silence. I've seen body camera footage where a driver essentially narrates their own prosecution because they can't tolerate quiet. This is why the anchor phrase must be rehearsed. Under stress, you will not invent composure. You will default to habit. If your habit is explaining, you will explain. If your habit is asserting calmly, you will assert calmly. Another mistake is arguing the law roadside. Drivers quote constitutional amendments in an aggressive tone. They challenge authority. They escalate. That rarely ends well. The roadside is not a courtroom. It is a controlled environment where the officer has tactical advantage. The goal is not to win the argument in that moment. The goal is to preserve the argument for later. You can assert your rights without hostility. Tone matters. Body language matters. Hands visible. Movement slow. Voice steady. Officer, I don't consent to any searches, and I would like to remain silent. Then stop talking. Here's where this gets complicated again. There are exceptions to everything. If an officer has probable cause, say they see contraband in plain view, or they smell marijuana in jurisdictions where that still matters, or they observe open containers, your refusal will not stop a search. The automobile exception allows warrantless searches if probable cause exists. Your phrase does not override established doctrine. What it does is prevent you from supplying the probable cause yourself. Let me give you a realistic example. A driver is stopped for failing to signal. The officer asks routine questions. The driver nervously admits there might be an old pipe somewhere in the car but insists there's no drugs. That single statement just created probable cause to search for paraphernalia. The search expands. A small bag is found in a backpack. Charge escalates from traffic infraction to controlled substance possession. The original violation did not create the charge. The conversation did. Now, let me be honest with you about something else. Some officers will ignore your assertion. They will continue asking questions. They may phrase it as casual conversation. They may say, I'm just trying to help you out. This is where discipline matters. You repeat the phrase, calmly, not louder, not angrier, just consistent. I don't consent to any searches, and I would like to remain silent. In court, repetition matters. Judges look for clarity. They look for invocation. A mumbled half-assertion can be interpreted as ambiguity. Clear, polite repetition creates a record. There is also the mistake of consenting out of fatigue. After 15 minutes, 20 minutes, drivers want the encounter to end. They say yes simply to make it stop. But consent given after prolonged detention can still be deemed voluntary unless clearly coerced. Time pressure is uncomfortable, but it is rarely legally coercive on its own. This is where it turns again. Officers operate under their own psychology. They deal with unpredictability daily. They look for cues of danger, sudden movements, argumentative tone, erratic behavior. These trigger heightened scrutiny. When you assert your rights calmly, you signal predictability. You reduce perceived threat. You become boring. Boring is good. Another mistake is lying. People believe a small lie will protect them. It almost never does. Officers compare statements. Inconsistencies create suspicion. Suspicion leads to deeper investigation. If you choose silence, you eliminate the risk of contradiction. Now, this is the part most people really misunderstand. Asserting your rights may result in a citation you might have talked your way out of. Yes, that happens. Officers have discretion. A cooperative, chatty driver may receive a warning. A silent driver may receive a ticket. That is the hard truth. But a warning is discretionary. A criminal charge is life-altering. You must decide which risk you are managing. I have stood next to clients who said, I was just trying to be nice. Nice does not translate into legal protection. Clear boundaries do. The law does not punish silence. It cannot be used as evidence of guilt in most circumstances, but it absolutely uses your statements against you. I have read transcripts where prosecutors highlight casual roadside comments as key admissions. Words spoken in stress become pillars of the case. This is the trap. The stop feels informal. The consequences are formal. There is nuance, of course. You must provide identifying information where required. You must comply with lawful orders regarding license and registration. Physical resistance or refusal to provide required documentation can create separate charges. This is not about defiance. It is about precision. Comply physically. Decline verbally. If the officer ignores your refusal and searches anyway, do not physically interfere. Let it happen. Your battle shifts to the courtroom. Suppression hearings are won on calm records, not roadside confrontations. I want you to imagine the next time you see those lights. Your pulse jumps. Your hands tighten on the wheel. The officer approaches. Questions begin. Instead of improvising, instead of explaining your entire evening, instead of attempting to manage their perception of you, you breathe once and you say the anchor phrase. I don't consent to any searches, and I would like to remain silent. Then you stop. Silence feels powerful when it is intentional. Here's where this gets complicated one last time. Rights are not shields against inconvenience. They are shields against self-incrimination. You may still receive a ticket. You may still be detained briefly, but you dramatically reduce the risk of transforming a minor infraction into a criminal prosecution fueled by your own voice. After hundreds of videos, after countless hearings where everything turned on whether someone clearly invoked their rights, I can tell you that most escalations were preventable, not because the driver was guilty, not because the officer was evil, but because the moment was unmanaged. This system runs on procedure and statements. Remove the statements, and you remove a critical building block. Rehearse the phrase until it feels natural. Say it out loud in your car. Say it until your tongue no longer trips over the words, because when adrenaline surges, you will not rise to the occasion. You will fall to your training. And the training I want you to have is simple, calm, and unshakable. I don't consent to any searches, and I would like to remain silent.